a couple elements before we get going. Today we have confirmed that the Minister of Justice will be available for the kickoff of our study on C9 on Thursday, with 1 hour provided for him exclusively, and then an hour as customary with officials for the second hour. So that is some good late breaking news. I just called this meeting to order. Welcome to the meeting number 6 of the House of Commons on the Standing Committee of Justice and Human Rights. Mr. Brock.
Thank you, Chair. Thank you, Chair. I appreciate we had some discussions before you hit the gavel about some housekeeping matters, and I appreciate the position you took, but I think that this is something that probably should be dealt with right off the hop. I don't think it's going to be very complicated or very lengthy, but I submitted a motion, tabled a motion last Friday. It's, I believe, in both official languages. Every member of committee has that motion. I'd like to move that motion at this time and read it out into the record. That the committee continue its study entitled Bail System Sentencing and the Handling of Repeat Violent Offenders in Canada, concurrently with the review of Bill C9, an act to amend the Criminal Code, hate propaganda, hate crime, and access to religious or cultural places, provided that one meeting on each study be held weekly. And regarding its consideration of Bill C9, the committee, A, dedicate at least 10 meetings to receive witness testimony, B, invite Sean Fraser, Minister of Justice and the Attorney General of Canada, for no less than 1 hour, and C, invite departmental officials and other witnesses deemed relevant for the purposes of this study. Echoing my comments from last Thursday, Chair, I believe that both C9 and our particular motion, or not motion, but study that we've agreed to, and we've heard several witnesses over a course of several days, is equally important. And I believe that we can accomplish both studies all at the same time. There is a pressing and ongoing need to have this discussion regarding sentencing and bail reforms. So it would be our preference, at least the Conservative team, to continue doing that on a week-to-week basis. Thank you, Chair.
Mr. Brock, let's have this discussion at the end. We'll reserve, it shouldn't take a long time, but let's reserve 10 minutes at the end. We can cut some of the witness testimony short, but since they're here and ready to go, I'm confident that we can dispense with this at the end of proceedings if we reserve 5 to 10 minutes to do so.
Provided that we can establish 10 minutes remaining in our allotted time.
And we'll do that. We'll do that at the end, and I see heads nodding, so that should be acceptable. Thank you. Mr. Lawton, we're moving on to now. We'll move this to committee business. Welcome to meeting number 6 of the House Standing Committee on Justice and Human Rights, pursuant to Standing Order 182 of the motion adopted on September 23rd, 2025 this year. The committee is meeting to continue its study on bail, sentencing, and the handling of repeat violent offenders. Today's meeting is taking place in hybrid format. The witnesses in the second hour, I believe, will be mostly on Zoom, pursuant to the standing orders, and we have a member as well present on Zoom. Before continuing,
I'd like to remind all in-person participants to consult the guidelines on the cards on the table in front of you. These measures are in place to prevent acoustic shocks and audio incidents, to protect the occupational health and safety of interpreters and the safety of all. You'll also note that there's a QR code available which sends you to an awareness-building video.
More reminders. I know members, even the new ones, are getting seasoned, but I do want to remind you that I recognize you by name before speaking. Those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Please also select the language, the official language of your choice and convenience on the proper channel. Reminder again that all comments should be made through the chair.
The clerk of the committee and myself will do our best to maintain order and the speaking order, and we'd like to thank you for your patience and understanding in that respect.
The guests, we have with us Nicole Myers, Professeur agrégé
Point
du
of order,
département de sociologie de Queen's University, Michael Spratt, avocat criminel de Abigail Goldstein,
criminal lawyer partner at AGP LLP.
Association, Boris Patensky, President. Before I begin, Mr. Lawton, in your point of order.
Thank you. Again, I concede that I'm new here, but my understanding of the standing orders is that when a motion is tabled, it is a live motion. We did not vote to adjourn debate on that motion, nor did we reach a consensus on that. So if there is, in the interest of expediency, a desire to dispense with the motion, I'm sure all of us can unanimously agree to adopt that motion and move on. But I don't want to get us into a situation where we end up with potentially, not to single anyone out, but a party deciding to filibuster that motion, which pertains to a meeting that we're having in 2 days, without us having an opportunity to adopt that. So I think, respectfully, Chair, the motion is still live before this committee. And if we do want to move on to witness testimony, which I'm very eager to do, we can adopt the motion unanimously if my colleagues opposite agree.
No, I think there was nodding of heads to move this to the end for 10 minutes. So
well, no,
we'll deal with it then.
you told me that while I was trying to speak on that, Chair.
No, you
so
weren't.
we didn't actually agree.
Yeah.
Monsieur le Président, l'interprétation me dit qu'il y a...
Mr. Chair, the interpreter's signalling there's a problem.
Anglais, français, français. Vous entendez? Vous nous entendez, par contre?
Can you hear us now? Well, I was listening to the floor, but I was told that the interpretation was having issues. Can we just double-check the interpretation? It's not the first time that this is occurring. If we can just resolve the issue right off the bat, that would be ideal, because we'd like to move on to the witnesses, please.
Ça fonctionne, Monsieur le Président.
Okay, parfait.
It's working, Mr. Chair, thank you.
What we agreed was to move this to the end, and we'll be able
We
to
did not
make this.
agree to that, Chair.
Well, that's what I heard, and that's the ruling.
No, that's what you said, Chair.
Okay,
We
well, let's
didn't
move
agree.
on since that's the ruling. Thanks.
I move to challenge the ruling, Chair.
Well, you can move it all you want, but we're moving on to the witnesses. Let's start with, and we will move this to committee business and have that discussion with 10 minutes remaining. We all want it. This is an important study. We all want to get on with it, so let's get on with it. I just introduced the 3 witnesses for the first hour. You each have 5 minutes. Let's go in the order that appears before me, with Mr. Batensky starting first. The floor is yours for 5.
Thank you very much, Mr. Chair. Thank you, everybody at the committee, for having the Criminal Lawyers Association and for allowing me to address you on their behalf. Our organization represents nearly 2,000 criminal lawyers across Canada, many of whom are in the front lines of our courts and bail and sentencing courts in every province and every territory in Canada. Our members are also members of our communities. We live in the same communities where the victims of crime live, where police officers live, and where everybody here lives. We want the exact same things in terms of public safety for our children that you want for yours. And we want to live in safe communities in dignity and harmony with our neighbors, and to enjoy the rights and freedoms that we all enjoy as Canadians. Personally, I was called to the bar in 1993. I've spent much of my career dealing with issues in bail court, and I've litigated these issues in a number of provinces and at the Supreme Court of Canada. And the issue of bail and bail delays have been persistent, and they have plagued our courts for about a quarter century, at least in my own experience that I'm dealing with. I provided some speaking notes, and there's some footnotes. I welcome everybody to review them. I'm not going to go into all those details. Our position from the CLA can be summarized this way. Number one, the bail system is not lenient, and the system cannot be perfect. It's important to recognize, contrary to many reports, that it is not easy to get bail in Canada. It's certainly not easy to get bail in a timely way, and it's not easy to get bail without facing unnecessary terms and conditions. It's also important to recognize that having a successful bail system that maintains public confidence does not and cannot require perfect compliance. We must accept, as the Supreme Court of Canada has, that predicting future dangerousness is, quote, notoriously unreliable, and we will inevitably lead and have unexpected and unfortunate negative outcomes. The only way to remove all risk for those on bail is to eliminate bail for all charges for all offenders. And of course, even if one ignores the constitutional barriers to that tongue-in-cheek suggestion, the criminogenic nature of our detention facilities would even make that a net negative from a public safety standpoint, if measured over a moderate period of time. Simply put, we cannot jail our way out of any public safety risks that will always accompany bail and sentencing decisions. Addressing the problem of repeat violent offenders. This was discussed in Bill C-48 when we were here last time to make some submissions. That bill was designed to have targeted changes to the criminal code's bail regime to address, quote, serious repeat violent offending with firearms, knives, bear spray, and other weapons, and to address, quote, the enhanced risk posed by intimate partner violence. All of these were addressed through the primary mechanism of creating additional reverse onus bail provisions at that time, and that were designed to apply to certain individual and certain enumerated offenses in certain circumstances. Today, there is ongoing dialogue about adding additional reverse onus provisions for the same general reasons. The position of the CLA is similar to the position taken by various other organizations that have appeared before this committee. Decisions to change bail legislation must be evidence-based and not the product of public sentiment that is stoked by individual cases or by partisan politics. Our submission is not based on the constitutionality of reverse onus bail, but it's simply based on our lived experience and the experience that we've seen in our courts. Reverse onus bails do not lead to more detention orders. They lead to slower bail cases. They result in more cases being delayed in the bail courts and more people waiting for their bail cases to begin. In our submissions in 2023, we predicted that this will lead to these types of delays, and that prediction has turned out to be 100% accurate, at least in Ontario. Further enactments of reverse onus provisions or other barriers to bail will only exacerbate these problems. In other words, these barriers to bail will have a measurable and inverse effect on public safety, at least in a medium or long term. Remand centers, as I said, are highly criminogenic. Whatever short-term gains you realize from keeping a specific individual in custody without bail for that period of time, they will be outweighed by the increased risk of public safety from that same individual when he or she is eventually released. And for every individual who loses a job, housing, or a bed in a shelter or a spot in a treatment program simply from having their bail hearings delayed, even if bail is eventually granted, that individual will also contribute to an overall increased risk to public safety in our communities. We recommend 3 discrete suggestions, and I'll be quick about this, noting my time, that will assist in bail without addressing bail delays. First, in my respectful submission, Parliament can legislate a mandatory right to proceeding with bail the day of, within 24 hours if you're ready to go. Second, adjournments for matters that are not reached should be outlined right in the criminal code. Bail adjournments should only be granted if requested by the prosecution for legitimate investigative reasons. And third, if those guarantees are not met, then bail should be deemed not to be pursued by the Crown, and release should be granted subject only to the mandatory conditions regarding weapons and protection of victims that exist in the criminal code. I strongly urge the committee to consider some of these suggestions and to use this as an opportunity to address the real problems we have in our bail courts. In my respectful submission, we can accomplish much more regarding public safety by adopting those measures than by some of the ones that are being publicly discussed. Thank you.
Thank you. Mr. Spratt, over to you.
Thank you, Chair and members of the committee, for the invitation today. I'm a criminal defense lawyer, and I spend most of my time in court. And I wish I could tell you that Canada's justice debates were guided by evidence, but they're not. Too often, they run on vibes and misinformation. Lately, we've seen sweeping justice reforms proposed after a few high-profile cases, usually before the facts of those cases are fully known. That might be good politics, but it's bad policymaking. We all remember the Zamir case in Toronto. When Mr. Zamir was released on bail, politicians and police leaders declared the system broken. Then the jury heard the evidence and found him not guilty. And that's the entire point. The presumption of innocence matters. Bail is how a free society honors that principle while protecting the public. When we legislate before we know the facts, we don't fix the problem, we create new problems. So let's talk about some facts. First, bail's not easy to get. In Ottawa, my clients wait days and sometimes weeks just for a bail hearing. When there's serious violence or breaches or weapons involved, police and Crowns rarely consent to the release. And bail courts take those cases very seriously. They look at the criminal record, the offense, the plan of supervision, the evidence, and public safety. People are released, but calling this a catch and release system is a misrepresentation. Second, even when a release is granted, it's far more restrictive now than it used to be. Ontario has seen an expansion in the use of GPS monitoring, for example. 5 years ago, it was exceptional. Now, it's quite routine. Third, we're detaining more people than ever. Our jails have never been fuller. About 80% of inmates in Ontario are in remand, awaiting a trial while presumed innocent. Fourth, the conditions in remand are inhumane. Our courts have said so repeatedly. After an extensive review of prior cases, the Superior Court found that the conditions at the Toronto South Detention Centre failed to comport with basic standards of human decency. Why? The court found that that was a deliberate policy choice to treat offenders in an inhumane fashion. And just last month, the Ontario Court of Justice found that things have gotten even worse. They haven't improved, calling the conditions so appalling that it's hard to find words to adequately condemn them. My clients confirm what those judges have found. Triple bunked, on the floor, beside a toilet, no visits, no fresh air, endless lockdowns, no programs, no counseling, and violence born of scarcity. If you were to design a system to increase reoffending, this would be it. That should matter to everyone. People don't emerge from these conditions better citizens. They come out cut off from family, treatment, school, work, and housing, more traumatized, less stable, and more likely to reoffend. Now, onto some legislation and a myth that we just need to dispel. It's been a popular talking point to blame Bill C-75 and the codification of the principle of restraint for the so-called bail crisis. That's wrong, in fact and law. C-75 simply codified what the Supreme Court has already said. Restraint and the latter principle aren't just suggestions, they're constitutional guardrails. And let's be clear, proposals for mandatory detention or limiting bails for certain offenses run headfirst into the Constitution. The Supreme Court's already struck down mandatory minimums for the same reason. They ignore the individualized, proportional analysis that the Charter requires. They also don't work. Studies show that this type of one-size-fits-all justice policy can actually increase the rate of reoffense. If the goal is safer communities, mandatory detention isn't the path. It's not the solution. It's just an illusion of one. Now, no system's perfect, so what could actually help? Let's go through these quickly. Real bail supports. Give the courts options beyond jail. Expand supervised bail beds, culturally competent supports, and third-party monitoring. 2, treatment on demand. Fund inpatient and out-of-patient mental health and addiction treatment and tie that to bail and probation orders. 3, smart compliance. Police budgets, have you noticed they always keep growing? How about we use some of that growth to actually do targeted checks on high-risk cases? 4, use the tools you already have. If a court gets a decision wrong, and sometimes courts get things wrong, you appeal it. That's how you fix errors without ripping up the Charter. 5, fix the jails. Remand conditions are a public safety issue. 6, tell the truth. Wait for facts before rushing to a microphone. Those accused of serious violence are already the most likely to be detained, and the law reflects that.
Michael, if you could sum up, please.
Of course. None of this is soft on crime. It's just sober thought. We're always going to need to detain some people because risk can be real, but we should do it sparingly, lawfully, and humanely. The presumption of innocence is not a loophole. It's the backbone of a fair system. Restraint is not weakness, it's discipline, and evidence, not vibes, should drive decisions that touch on liberty and public safety. Thank you.
Ms. Myers, the floor is yours. 5 minutes.
Thank you. I'm a criminologist and associate professor at Queen's University. I've been studying issues around bail and pretrial detention for over 20 years, having observed hundreds of days of bail court, witnessing the decision-making process for thousands of people, interviewing justice professionals and accused individuals. It is from this position that I speak to you today. When tragedies occur, it is easy to look to the law as the culprit, to think that with some adjustment we can prevent further tragedies. We do this rather than the more complex task of addressing the root causes of crime that are supported by empirical evidence. The bail law is not responsible for these tragedies. The effectiveness of narrow rather than wholesale bail reform will be limited, as the problems with the bail system are not ones of leniency. For the most part, bail is about making predictions, and predictions about humans are seldom 100% accurate. We only ever hear about the people charged with new offenses. Nobody ever talks about the number of people who are released into the community, who show up as required, and who do not commit offenses. For every person who commits a serious offense, there are scores of others who do not, and we are never going to be perfect at predicting the ones who will go on to commit an offense. The bail system is replete with problems. Keeping people in pretrial custody is not one of them. It is already difficult to get bail in this country. The issues with bail lean far heavier on the administration of the law rather than with the law itself. I caution you against proceeding with efforts that will make it easier to lock up legally innocent people when we are already quite good at doing so. We can all agree that public safety is important. People should feel safe in their communities. The difference is in views on how we get there. While tempting to be drawn in by catchy slogans like jail not bail and revolving door system, these are not simply mischaracterizations. These are factually inaccurate. I encourage you to pursue empirically supported reforms rather than reforms that will make the problems with the bail system worse, increasing rather than remediating risks to public safety. So let's get some facts straight. Canada's bail system is the harshest it has ever been. We have never before held this many legally innocent people in custody. The most recent data indicate over 19,000 people were in remand on an average day, and less than 6,000 people were serving a sentence in provincial custody. Across the country, 76% of the provincial jail population is in remand. The rate with which we hold people in remand has quadrupled in the last 40 years. Another way to look at this is 103,000 people were punished by being admitted to pretrial detention, and less than 46,000 people were punished by being admitted to federal or provincial sentenced custody combined. Internationally, we stand out amongst comparable nations as holding the highest proportions and rates of people in pretrial detention. As a free and democratic nation, this is not an enviable achievement. It is critical to strongly emphasize that it is Indigenous peoples, Black and other racialized people, people experiencing poverty, as well as those who are struggling with mental health issues and substance use, who are dramatically overrepresented. Said differently, it is the most marginalized in society who experience the most punitive aspects of our system, and any efforts to tighten the bail system will amplify these disproportionate impacts. Being accused of a crime does not make it so. In 52% of cases in Canada, all charges against the accused person are withdrawn. That means only 46% of accused people are ever convicted of an offense. For those who are convicted and receive a custodial sentence, they are rightly given credit for their time in custody. The difficulty is the sentence then appears artificially short, perpetuating inaccurate perceptions of leniency. The current system has inverted the process, where the punishment commences upon arrest and accusation rather than conviction. We routinely punish people upfront prior to determining guilt. In doing so, we reduce any sentence that may be imposed post-conviction, reducing any available opportunities for rehabilitation. This says nothing of the heavy consequence for the hundreds of thousands of cases that conclude with all charges being withdrawn. For many people, pretrial custody is the punishment before and often in the absence of any conviction for wrongdoing. Now, call me old-fashioned, but in my view, before we punish individuals, we ought to convict them of the offense first. It would be better to focus our attention on holding guilty people accountable rather than punishing legally innocent people for something they may or may not have done. An accusation can send somebody's life sideways, disrupting the very community connections that provide stability and are known to protect against crime. We must be mindful that custody makes it more, not less likely for people to engage in crime. Now, crime goes up and down for many reasons. Neither bail nor sentencing laws are one of them. Tightening the bail law will likely increase the number of legally innocent people in custody and do almost nothing to reduce crime or improve public safety. We cannot incarcerate crime away. If incarceration worked, the United States would be the safest country in the world. I encourage you to avoid legislating blanket requirements such as automatically denying bail, creating mandatory minimum sentences, or any three-strike policy. It is critical that discretion is maintained, or you risk legislating unfairness and injustice. Indeed, research demonstrates Canadians want something more akin to structured discretion or presumptive guidelines rather than mandatory minimums. Resist falling for factually inaccurate assessments about the bail system. This in so many ways is about the administration of law, not the law itself. It is the provinces that are best positioned to implement measures to improve the system, not by building more jails, but by focusing on efforts to improve the operation of the court system.
If you could complete your
I implore you to question the narrative that the bail system is lenient. There are many problems, none of which will be addressed by making it easier to incarcerate innocent people. Thank you.
Thank you, Ms. Myers. Thank you to our guests. The rotation goes as follows. Mr. Lawton will be first again for 6 minutes, followed by Ms. Latanzio, puis ensuite Monsieur Fortin, 6 minutes chaque. On va essayer de faire un peu de la deuxième ronde.
And we'll try and have a second round. So we're going to try and stop this session at 4:55 p.m. first. The second round, Mr. Bacro in first, followed by Mr. Maloney, Mr. Fortin, Mr. Rock, if we time permitting.
Mr. Lawton.
Thank you, witnesses, for your time and testimony today. I'd like to start with you, if I could, Dr. Myers. You mentioned that the bail system is the harshest it's ever been. Those were your words. Do you think bail should be made easier to access after the culmination of our research here?
I think it absolutely needs to be more readily available for a lot of people in custody. I think we can acknowledge that there are some people who are perhaps too risky or the allegations are too serious. We want to focus our attention on those, not an automatic decision to detain, but to be able to focus on those. We need to make release more available for all kinds of others who are there for more minor reasons.
So what are the sorts of offenders that are being detained pretrial now that you think should be getting bail and aren't and don't have it available to them?
Most of the folks that have been charged with nonviolent offenses.
Okay.
And that would be the bulk of the individuals that go through our bail court.
You talked about in your career as an academic, quote, interviewing justice officials and accused individuals.
Yes.
You didn't mention victims, victims of crime. Have you interviewed them as part of your research?
No, I study the criminal justice system, not rather than what happens with victims.
Do you think that the experiences of victims should have any bearing on how offenders are treated by the justice system?
Absolutely. The victims are critically important in all of this, but nonetheless, we need to remember the very important constitutional rights that we have and that those must absolutely be protected, and that while there may be harm to victims, we can provide those supports that they may need outside of the criminal justice system where they would be far better served.
But why in 20 years of researching this has interviewing victims not factored in if you think they do have a role to play in the way these decisions are made and these policies are drafted?
Because it has not been part of my research agenda. I've spent the time sitting in court and talking to those who I'm interested in the process of bail. I'm sitting in court. I've heard from many of victims about their experiences that comes out in the open court.
So you do indicate that people should, I'm paraphrasing, but you said they should be punished after a conviction. Yeah. So who should be held behind bars pre-trial in your view?
I think a very limited number of people. If we go back 40 years, we used to be sitting much closer to about 20 or 30% of those in our provincial jails were in pretrial detention. I suspect those are the folks that needed to be there, while other folks were able to be better managed in the community.
Do you think that anyone who's charged with first-degree murder should be behind bars pretrial?
I would leave that to the decision makers to properly examine the information that's been provided to assess the risk and make those decisions.
So you think bail for first-degree murders is actually legitimate at times?
I think in some circumstances it could be possible. I'm not a lawyer. I'm not the one making these determinations, and I trust the professionals who have all of the available information to be able to make the appropriate decision in these cases.
Another comment you had made was that we cannot predict future behavior. You were basically you were saying that we can't predict who will commit future offenses. So I would assume from that you're against 3 strikes, you're outlaws that have been proposed, correct?
Absolutely.
So how many convictions is enough for the system to actually say, we have a pretty good indication this person is going to reoffend?
Well, you know, we might be able to look at measures that indicate that somebody has a record of offending, and those are exactly the kinds of pieces of information that are considered by those who are making bail decisions.
So you do think multiple convictions you do think should actually count against someone in their bail eligibility?
I think it should be a factor that is considered and weighed appropriately. It should not be the driving and the only reason. Each one of those convictions, that individual's already been punished and held accountable for those offenses. At some point, we have to acknowledge that they have moved on. Let's focus on what the allegations are saying of what they've done now.
So someone who's committed murder against an intimate partner, someone who has robbed a bank, someone who has committed violent offenses. They
Allegedly.
are arrested. No, I'm talking about someone who's convicted. They have 5 convictions under their belt. Your view is that that is a clean slate if they've already served their sentence the next time they're up for bail?
I said nothing about it being a clean slate. I said
You did. You said they've already paid their price.
They have paid that price, but nonetheless, the criminal record is a critical component that is considered by decision makers when making the evaluation on the level of risk. We cannot perfectly predict. We can make predictions on the basis of offenses or records, but they are imperfect, meaning we are getting it wrong a lot.
Mr. Spratt, you mentioned in your comments that we have a mechanism already, which is appeal, but there have been numerous instances that people have committed often violent offenses well out on bail. Is the process working? Is the process of letting the Crown appeal if they feel bail is too lenient, is that working?
Yes.
And what would you say needs to change in the bail system? Keeping in mind we have about 30 seconds left here.
Well, I think there's a number of things that need to change. We need to have timely bail hearings. We need to have less volume in bail court, so get rid of some of those low-level property offenses that those people are taking up time that the court can use to consider some of those higher, more serious cases. And I think that we need to have more access to supports. There's some very good programs in Ottawa, the John Howard Society Bail Program, independent third-party verifications. Things like that can go a long way to mitigating risk and making sure that we're not filling our jails with people who will come out in a worse situation and are legally not guilty until their trial, until they're convicted.
Thank you. Oh, I'm sorry. I thought I had 5 minutes, so I apologize. Thank you. bonus round, Mr. Spratt. So as you look at this system, would your view also be that bail is currently too hard to get?
It is.
And when you look at violent offenders that are recommitting, we have brought a number of these cases forward before this committee. What is your message to victims who would have a loved one that would still be here if an offender were kept behind bars instead of released on bail?
I mean, look, I think that one of the things that we don't do well is talk to people who are victimized and are the victims of crime. I think the wrong way to respond is with statistics. I think it's wrong to say we've never been safer, that individual A over here was released on bail for a first-degree murder and then was found not guilty, that was innocent. I think that is not a good way to respond. I think it's appropriate to respond with compassion, and I also think it is appropriate when responding to those individual people and the community as a whole. And I say this to all the parliamentarians, to make sure that we don't weaponize the criminal justice system as a political wedge issue, and to make sure that when we're talking about rates of offense, the purposes of the bail system, risks and trade-offs and the balancing of rights, that we do that accurately and not for political reasons. I think that goes a long way to helping people understand. I know that criminologists have done lots of research, and people might feel upset or that the criminal justice system is unjust, and especially when looking at particular cases. But when they're provided with all of the information and all of the facts and educated about the principles, a lot of that dissatisfaction goes away.
Thank you. Madame Latanzou, 6 minutes.
Thank you, Mr. Chair. Thank you for being here today and contributing to this valuable study. My first two questions will be directed to you, Mr. Bytensky. The jail not bail framing of Bill C-242 may sound very appealing, but it ignores the nuances of the existing bail law that we have today. How does the measure of Bill C-242 risk undermining proportionality and the fundamental purpose of pre-trial release decisions?
Well, I think as all three of us have been saying today, our existing laws give us the necessary weapons to assess risk and detain those that pose risk that is deemed to be too high to the community. That's what our trained and experienced judges and justices of the peace in Ontario and throughout Canada are trained to do. We want to ensure that the people who deserve to be detained, in other words, those who pose an unmanageable risk, are in fact detained. And imposing artificial standards that won't reduce the risk and won't actually have any meaningful impact of protecting the public, but simply because they're catchy or they sound good, like bail not jail, or jail not bail, excuse me, won't take any steps forward in terms of ensuring that our system gets it right. And what we need to do, as all of us have said, is get rid of the low-hanging fruit, the things that tie up our courts, give our courts more time to deal with the serious cases. Rush decisions are not good decisions. If we give our courts the weapons to deal with the serious cases, they're going to get it right as often as they can, more often than they get it right now. And no one's saying that dangerous people shouldn't be detained. We're simply saying that we detain too many others that we don't need to detain in our hunt to try to make sure that we, to try to cover off anybody potentially dangerous when we have way too much overreach when we try to do that.
You've also spoken publicly about proportionality and fairness in sentencing. How do we maintain those values while responding to public safety concerns?
Well, because, again, if we were to randomly select people from the street to act as judges for any given case, then we might want to have some guidelines that we legislatively set out that that these untrained people would have to impose on any particular case. But we go through a rigorous process of selecting the best to be our judges. We have to entrust them that they will apply the law that's handed down from the Supreme Court of Canada and provincial appellate courts appropriately. And it's their job to assess any particular case and apply the proportionate, proper sentence for every individual. It's an individualized process. When we go for medical treatment, we don't say that every person treated with cancer has to be treated with the exact same drugs in every single case. We individualize the treatment plans based on the person that's getting the treatment, and we should be doing the exact same thing when we're sentencing somebody for a particular crime. And some people should be sentenced harshly. I accept that for public safety, but we got to give judges the tools to do the right thing in every case.
My next two questions will be directed to you, Mrs. Myers. In your research on bail and pretrial detention, whatever evidence have you seen that is data-driven approaches and that can improve the outcomes without compromising public safety?
Thank you. I think one of the most important things that we can look at is thinking about the ways we can support people in the community. I think what we want to be doing is thinking about when folks are coming out, how can we best support them? What is it that they need to be able to continue to come back to court as required and to comply with all of the conditions? And so these are some of the things that were already spoken about by Michael Spratt here, talking about bail verification and supervision programs or bail beds. But these are the kinds of opportunities that can provide the kind of support that folks may ultimately need. The other critical thing that we really need to be doing is sort of a system minimization, finding alternative ways of holding people accountable for relatively minor things. It's not to say that we don't do anything, but to the extent that we can keep them out of bail court so we can really focus our time and resources on those things that are most risky or most dangerous will allow us to not only move people through the process in a timely manner, but really reserve detention for those who are it's absolutely required.
You've written about the importance of proportionality in bail decisions. What safeguards would best ensure that principle is maintained in real-life practice?
I mean, that's a really good question. It might be a little beyond my legal expertise here, but I think making sure that we maintain the essential principles of our bail system and keep those at the forefront of mind and not letting sort of rhetoric get involved in making these very difficult decisions. Some of the things we may want to even think about is what might be some of the hurdles or barriers we want to have in place before we admit someone to custody. So if we're thinking about proportionality in the context of sentencing, where there's supposed to be some equation between the harm and the moral blameworthiness in the sentence, at bail, perhaps we're looking, going, if this individual was to even be convicted, would they even get a custodial sentence? Because we're holding a lot of people in custody, and they were very unlikely to receive a custodial sentence at all.
Okay. Mr. Spratt, you've said in past committee appearances that reactionary bail measures risk creating longer delays and less efficient justice system. You said that again today. Do you believe that Bill C-242 would exacerbate those pressures and further overwhelm provincial court resources?
Not just provincial court resources, but the Superior Court. The idea that we have more bail hearings in the Superior Court is only going to tax a system that is already at its breaking point, a civil system that is falling apart under delay, and a criminal system, we've heard about this for the last number of years, where serious cases are at risk being thrown out of court because of a lack of judicial resources. I think part of the problem with bills like that, despite catchy slogans, is they don't look at the cost. When you detain people and detain more people in these conditions, inhumane, terrible conditions, there's a cost to that. And one of the benefits might be that you prevent one person from reoffending. But when you detain thousands to do that, there is a downstream cost, and that cost is steep, given the conditions, given the resources, and given the other drawbacks that we've all spoken about.
Thank you, Mr. Thank you, Mr. Spratt. Time's up, Mr. Tanzio.
Thank you.
Monsieur Fortin, la parole est à vous, 6 minutes.
Mr. Fortin, the floor is yours, 6 minutes. Thank you, Mr. Chairperson, and thank you to our 3 witnesses in attendance today. I'll be speaking in French. I understand this is an additional challenge, but unfortunately, or fortunately in my case, and in the case of Francophones, it is what it is. So listen, first, I'm pleased that you're here. I'd like to talk about rehabilitation, but I'd also like to talk about how we can address this issue at hand. Obviously, I'm in favour of the presumption of innocence. I believe that the system of releasing folks who aren't found guilty, that's a good system, but I also agree with the notion that when those individuals, i.e. the accused defendants, who pose a risk for the health and safety of the public, there are currently 3 conditions: risk to public safety, risk that they don't appear at the next hearing, and risk of a miscarriage of justice. There are 3 problematic situations that are of concern, evidently. Now, and of course, there are victims' rights that come into play. Our conservative friends often refer to this, and rightly so. We need to protect the public. But at the same time, we need to factor in victims' concerns as well as all of society's concerns. When a victim fears that the perpetrator might be released, it's not just them that's living in fear, it's many people in society that are at risk. So how do you reconcile rights and freedoms, i.e. the right to bail of the accused until they're found guilty, and the right of society and victims to be protected against wrongdoing that might strike one as predictable? There was a particular case that occurred in my writing. There was a person who was found guilty and broke their bail conditions, and he was released and killed his ex-wife. I agree. I imagine that all 3 of you agree that that's not right. But at the same time, how do you prevent against that kind of thing occurring? I'm sorry about the lengthy question, but I'd like to hear your thoughts about what the solutions are. How do we not flout the rights and freedoms of the accused, but at the same time ensure that society writ large and victims are properly protected under our judicial system? Mr. Letensky first, and then Ms. Spratt and Ms. Myers, or Dr. Myers.
So, thank you for the question. It is absolutely important to, if we're going to look at one case at a time, it's easy to do a retrospective analysis and say we got something wrong. But we have to look at things as a whole, as a system as a whole. If we're not good at predicting future dangerousness. So when somebody is arrested and they have a long history of violent offending, we can be pretty confident that they are a significant risk and that person will usually be detained. But if somebody is arrested on a minor property offense and they're released and then they go out and kill their spouse, we don't know how to predict that very well. And the only way to avoid that in retrospect is to jail everybody, which I've already said we can't do.
I agree. Oui, on ne veut pas mettre tout le monde en prison.
Yes.
Je m'excuse de vous interrompre, mais le temps est vraiment compté. Vous dites on doit regarder en général, on ne peut pas regarder des cas spécifiques, mais malheureusement, M. Bietensky, ce sont...
rules of thumb, but unfortunately there are specific cases that are the issue. And I trust the justice system. I trust justice's common sense. And I think that the vast majority of judges display good judgment. But as a legislator, how do I avoid these kinds of specific cases that you say that we shouldn't be talking about that are of concern to us? How should I ensure that those specific cases don't spoil the whole thing for everyone?
To accept that an imperfect system is a functional system. If 99%, I'm using that number intentionally, it's not the number, if 99% of the people comply with their bail, but one person commits a horrible crime, the system has worked. It has not failed. It has worked. We cannot achieve 100%, and if we aim to do that and think we failed otherwise, the system will not be seen by the public as working. But respectfully, we have to accept that there is an unquantifiable degree of risk that we cannot capture in any possible way. The test is substantial likelihood of free offending, and we do a pretty good job of putting those people behind bars. Just one final thought about your domestic violence case. There are thousands of individuals charged with domestic violence offenses every day that do not kill their spouses before their trial. They are rightly released on bail, but some of them will. And fortunately, we can't identify the ones in advance very well. And the solution isn't to jail everybody, because that will actually result in more violence and more harm to victims in the big picture long term.
Merci, M. Bietensky. M. Spratt?
Thank you. Mr. Spratt, on the same question, please.
I think as a criminal defense lawyer, I think that we're in a good position to talk about this because we don't just represent accused people. A large part of my practice is representing victims of crime as well. And I think one of the things that I hear most often from those people is that they want to make sure that when someone's released, that there are conditions imposed that allow them to feel safe in the community. And
Mais s'ils ne respectent pas.
But if they don't respect the bail conditions, what about that?
yes, as Mr. Batinsky said, the only solution to that is to detain everyone. And this is cold comfort to someone who's been affected by crime. But as legislators who look not just at specific cases, but everything, I would commend you to look more broadly. Because the answer, the cold answer, is, showing sympathy for that crime, but saying if we detained everyone, it would be even worse.
Merci. Quelques secondes.
Thank you. I just have a couple of seconds, do I? Sorry about that. Perhaps you'll have an opportunity in the second round if we proceed quickly. Second round, Mr. Baba, and then Mr. Maloney, followed by Mr. Fortin. 5 minutes, Mr. Fortin, 2.5 minutes as usual.
What year were you called to the bar?
1993.
And so you've been practicing defense, criminal defense for quite a long time?
I have.
And you're also familiar with various industry strategies, being president of the Criminal Law Association?
I try to keep up. There's a lot going on.
And so you can inform the committee truthfully about various strategic practices used by defense attorneys.
It's a very broad question, but for some of those strategies, yes, perhaps I can.
So I'd like to propose that we have a discussion about legal practices. Let's leave politics and policy aside for a moment. Judges have discretion to grant extra credit for time served pre-trial, correct?
Yes, they do.
And in your experience, that is fairly common during sentencing, to credit for time served?
If you're talking about the standard credit, it ends up being roughly the same as, it ends up being a zero-sum game. So somebody who spends 3 months in pretrial custody will get credit for 4.5, and if they were to receive a 4.5-month sentence, they'd be out in 3 months. So they'll end up doing the same amount of time in custody overall, typically.
Yeah, but we're talking about a credit of potentially 1.5 to 2 times.
Typically 1.5, and if you have our typical parole application, they would be released at 2/3 or sometimes earlier. But it's designed, the general rule is designed to make it an equal amount of time in custody, whether you spend it up front or after you're sentenced.
So 1.5 to 2 times for time served before trial is not uncommon.
1.5 is not uncommon. 2 times is no longer common. You're talking about things that have changed many years ago. So it used to be 2 times. That is no longer common, although because of the jail conditions that Mr. Spratz talked about, it is becoming increasingly common to grant enhanced credit. But that is not common. The common is 1.5, and that is what is almost invariably granted in every case.
So without referring to specific clients or to specific colleagues, do any of your colleagues in the criminal justice system ever recommend pre-trial custody time in order to reduce sentence?
Not anymore. It is not a worthwhile process. So there was a time many years ago when you would get 2 times the credit, and some people did adopt that strategy, and you could end up coming a little bit further ahead. It is no longer a winning proposition. If you do the math, it doesn't work. So you're actually better off getting bail and getting sentenced afterwards, not to mention the time will be much easier time spent in better conditions if you're sending it, if you're serving your sentence after sentencing, you'll do less time typically, and you'll serve it in better conditions. So nobody who knows what they're doing should be adopting that strategy anymore.
Okay. You were talking about custody credit for time served given various conditions. So we understand that there are situations right now, particularly in the Toronto South Detention Facility. What is your experience with respect to credit for pretrial custody served in that facility?
It varies greatly. It depends on whether you were triple bunked or quadruple bunked, and it's not just Toronto South. It's throughout Ontario and many institutions, and frankly throughout the country. So it's far greater problem than just the Toronto South. But yes, in light of some of these conditions, some judges in some cases are awarding enhanced credit. And that has happened, but I don't know a single defense lawyer that has ever adopted the strategy of keeping their client in custody longer so they can then argue for enhanced credit if their client is found guilty. Respectfully, it's not a strategy that I know that anybody would adopt.
We're not talking about a situation where bail is possible. Of course, we would presume that an accused would want to be out on bail. But let me take you back to that example. Could you please provide us with a few examples of situations where pretrial custody time could potentially even exceed twice, 2 for 1, for time served?
Yes, there have been examples where individuals were beaten in custody, where they were triple and quadruple bunked, where they were illegally strip searched. And there are examples in our law where judges have awarded more than 1.5 to 1, sometimes 2 to 1, sometimes even 3 to 1, I've heard. There are occasional rare cases where you have more than 2 for 1 credit being granted by some judges for truly despicable conditions. Yes.
Thank you.
Your time's up, Mr. Brown.
Thank you.
Mr. Maloney, 5 minutes.
Thanks, Chair. Thanks, witnesses. The biggest problem we have in this entire discussion, in my opinion, is the rhetoric that surrounds it. And it's appalling, quite frankly. We're trying to deal with important policy here. I think I'm on solid ground when I say everybody in this room and everybody I know wants bad guys in jails and the system to function properly. The problem is you take these individual cases, you sensationalize them, and it blows up, and every time you turn on the news, people get the wrong impression. The number of times I've seen, daily almost, people get, some heinous crime will happen in the city of Toronto where I live, and some politician will come on without even knowing who committed the crime yet, saying the person was probably out on bail. So the whole community thinks this has got something to do with bail, and it probably doesn't. So, I'm tempted to say, how do we stop that? But it's an unfair question, because unless you take it out of the hands of politicians, you can't. So what we have to do is find a way to tone down the rhetoric, find a system that works, find a solution that, creates an environment where everybody is confident that it works, because what we're really talking about in terms of the political side is making sure that the general public has confidence in our system. Most of the people around this table are lawyers. I think it's safe to say as well that they have confidence in our judges and our lawyers and the system as a whole. So I think it was you, Mr. Potensky, said, was talking about the delay. You had the mandatory right to a bail hearing in 24 hours. I understood that. I didn't get it in my notes. But what would you say is the biggest cause of delay in getting a bail hearing right now?
Because the nature of our litigation in bail courts, especially in Ontario, is that we cannot manage to complete our lists, and cases that are ready to proceed can't get reached because we have only so many hours in a day. We have in Toronto typically 25 cases that are ready to proceed with bail, and we typically get through 10 to 12 of them. So the math doesn't add up. Crowns need to consent to more reasonable releases. Fewer matters are being consented to than ever before, and it's creating an untenable situation. Now, look, as I said, the problem isn't just that we detain too many people. Others have said that. I'm not so sure that I necessarily want to go down that road too far. It's that we wait too long to release the people that get released, and they end up losing jobs, houses, treatment, all sorts of things. And the people that wait 2 weeks for their bail hearing may as well be detained because their lives are crushed, and that's what causes further harm. So
I don't know if you can answer this question, but typically how many bail hearings are waived because of these systemic delays? How many bail hearings are waived because if you only get through 10 of 25? What happens to the other 15?
They go over to another day, and then tomorrow's list will have 40 matters again, and matters don't get reached. It's very difficult to get your client into court, and people wait days in a queue to get a timely bail hearing.
And that's but there are cases where the bail hearing can be waived on agreement between the defense lawyer and the Crown.
Well, sure. Sorry, Mr. Spratt wants to. I think he's got some personal experience. If you don't mind, he can jump in.
You're quite right. Hearings can be waived. And the most insidious thing is this. I've got a couple of these cases going on right now. Someone's arrested on a minor offense, a property offense. And they can't get their bail hearing for the next 5 days.
Right.
I've had lawyers that work with me and myself sit in court day after day to reach the same bail hearing. And so at the front end, the Crown says, well, we could schedule your bail hearing. That might be available in 5 days, or you could plead guilty now and get out.
Right.
My clients who are innocent, the problem isn't, like Mr. Barber says, clients wanting to stay in jail longer to get time. The problem is innocent clients wanting to plead guilty to escape those terrible conditions that are caused by a deliberate policy choice of provincial governments.
Right. So part of the problem is there's not enough prosecutors, there's not enough jails. The jails that we do have, the Toronto Self-Detention Centers in my community, it was like building a new school and then you have to put portables out in the football field the next day. They just don't have the capacity. So all of these things play into the problem. The shortage of prosecutors, the shortage of courtrooms, there isn't enough capacity in the prisons. So it's systemic. All of these delays add up to a situation which right now is untenable. A Crown prosecutor who I know once said to me, the laws aren't the problem, the enforcement is. And the enforcement we're talking about is those things. It's the prosecutors, the prisons, and the jails. Isn't that right? And
Can be, and if I can jump in, and it doesn't help.
Just briefly, Mr. Potenski.
Yeah, it doesn't help when every Crown knows that if they agree to somebody's release, they're going to be criticized for it in the media by somebody, police officers, politicians sometimes. So there's a culture of refusing to consent in part because of that.
Monsieur Fortin. Merci, Monsieur Maloney. Monsieur Fortin, 2 minutes et demie.
Mr. Fortin, 2.5 minutes. Thank you, Mr. Chairperson. I'll use my 2.5 minutes to ask a question of Dr. Myers, who didn't have an opportunity to respond to my question earlier. I'll ask the same question again. What is the solution? And first, reiterate the figures, please. You mentioned a percentage of inmates who are in pre-custody whilst they're waiting for their trial, who are later found innocent. I'd like to hear those figures again, please.
Okay, there we go. Okay, so just to go back to the figures that you were asking about, when we look at our provincial jails, 76% of the people in our provincial jails are in pretrial detention. And then when we look at the proportion of cases that end with all charges being withdrawn, now this does include people who may have been released or in custody. We don't have the breakdown of data to only look at those who are in custody, but it's 52% of individuals have all of the charges they're facing withdrawn. We're only convicting about 46% of individuals.
Et votre opinion, comment on fait pour concilier la...
Your opinion, how do we reconcile the presumption of innocence with the need to protect the public? Because, of course, that's important. The presumption of innocence is important, but if society no longer has confidence in the justice system, well, that will be to our peril. Society needs to have confidence that the courts will rule fairly, and that trust is currently shaken. Your thoughts in the space of about a minute, please. How can we help the public trust the justice system once again?
I think to help the public, we need to make sure that we're providing them with accurate information about what's happening rather than feeding them mischaracterizations of a system that is apparently lenient when it's precisely the opposite of doing that. Protecting the presumption of innocence is critically important, but as has been said by all of us here, we do need to be thinking about victims and be thinking about community safety and public safety, and it is a balance. And we are left with the difficulty that we cannot perfectly predict, and so we're making imperfect predictions, but we want to do that as best we can. The way to do that, the best that we possibly can, is to get the minor stuff out of the bail system so that we can focus on that which is more serious. And that when we are making decisions, that we're making that quickly. Every single day in bail court, the most common decision is an adjournment. We make very few bail decisions every day in court, whether that's a consent release or after a show cause hearing. Every day, that is the most common outcome. If we can reduce that and we can make that bail decision much sooner, we can avoid causing all kinds of harm that come from that extra time in detention.
Thank you.
Merci à vous trois.
Merci à vous tous. This concludes the first hour of this meeting. Thank you, all three of you, for coming in. And we will take a brief pause for, you can leave, you're welcome to stay, obviously. But we have to do, because people are online, and there's a number of them, we have to do some sound tests. Yes, Mr. Brock.
Thank you. At this time, I want to revisit the motion that I moved at the first hour, the beginning of the first hour. And with all due respect, Chair, there was a challenge brought by my colleague, Mr. Lawton, to your ruling. You disregarded the challenge, which is incorrect. That's a procedural error. A challenge requires an immediate vote and a debate.
Do you want to, this is about the challenge itself, or do you want to revisit the motion? There's two things you're asking.
I want to, if we can revisit the motion without the challenge, I want to
That would be your
revisit the motion right now and allow my colleagues to say what they want to say about the motion. And if we had consent from all members of this committee, great. And if not, we'll move to a vote. But I don't want to take the chance that we set aside 10 minutes at the end of the second hour, and then all of a sudden someone decides to filibuster this. This is an important motion. Both studies, in my view, and our collective view, have equal weight and equal relevance, and we want to proceed with this motion.
Understood. I believe the Liberals have a point to this, Mr. Brock.
Thank you, Mr. Chair. I know that we have witnesses lined up for the second session, so I'd like to move that we reserve the last 10 minutes of this meeting to dispose or consider my colleague, Mr. Brock's motion.
What do you want to
Sur ce que Mme vient de dire,
On what Ms. Latenzio just said, if I may.
Table.
Yeah.
Okay, so we have to dispose of my motion before we entertain Ms.
You got a
Latenzio's
colleague,
motion.
right, you have a
Right?
colleague with their hand up.
Yes.
So just to be clear, Ms. Latenzio did not move a motion. So we're,
I just moved a motion to reserve the last 10 minutes of this meeting to dispose or consider of my colleague Brock's
point d'ordre, Monsieur le
motion.
Président.
On a point of order, Mr. Chair, listen, there was a decision earlier. Was it the right or the wrong decision? I don't know. But you said that there would be 10 minutes. You didn't say there would be 10 minutes between the 2 hours. I don't want to waste another 10 minutes. Either we do it now or we do it at the end. You handed down a decision. Whether or not it's right, I think we need to address Mr. Brock's motion forthwith and then proceed accordingly.
Hearing nothing else, let's vote on this motion. On the first one, the motion on the table that, no. On the motion, which is to bring it back.
Sorry, point of order. Isn't Ms. Latenzio's motion a dilatory motion? We have to vote on it first.
No, my motion was not disposed of,
Just asking, Larry.
okay?
Mr. Chair,
It's
can
a
we be
motion.
clear on what motion we are,
So
we need to dispose
perhaps-
of?
We're voting on motion, my motion, conservative motion.
Stated again, because there was unclear.
Sure, that the committee continue its study entitled Bail Systems, Sentencing, and the Handling of Repeat Violent Offenders in Canada, concurrently with a review of Bill C-9, an act to amend the criminal code, hate propaganda, hate crime, and access to religious or cultural places, provided that one meeting on each study be held weekly, and regarding its consideration of Bill C-9, the committee dedicated at least 10 meetings to receive witness testimony, invite Sean Fraser, Minister of Justice and Attorney General of Canada, for no less than 1 hour, and C, invite departmental officials and other witnesses deemed relevant for the purposes of this study.
So the motion is to resume the debate on this topic. And we,
point of order. The motion is not to resume debate. We are debating the motion. The motion is before this committee already. So
no, it's resuming it. Anyway, it's academic, but we are bringing it back for discussion. It's not to vote on the actual motion yet.
okay.
Mr. Chair, can we adjourn? Can we adjourn? Yeah.
No,
Can we adjourn debate on this?
we do have to discuss it now and and vote on it.
I believe,
I'm moving to adjourn debate on this motion.
Yeah, no, that you can't do that at this point. You do have to vote on it. All those in favor?
La motion qu'on a reçue.
The motion we received from the 3rd of October, it's the motion to resume the debate on the motion. Oh, I thought that was already decided. Well, the idea was to do it at the end. Let's do it right away.
People may want to speak to this motion still. I mean,
Yeah, but now we'll speak to the motion.
we didn't have that opportunity because we decided to push it to the end of the meeting.
So it's now at a vote, Mr. Maloney. To resume the debate on this motion. You can then speak to it. Yeah.
Mr. Chair?
This is a vote now,
Mr.
Ms. Lattanzi.
Mr. Chair?
It's a vote, Ms. Lattanzi.
Okay.
All those against? So the motion is passed. Let's resume debate on it.
Mr. Chair, I adjourn to resume the debate on this motion.
You move to, what do you?
To adjourn, to put an end to this and just carry on with the witnesses.
Okay, we'll have to vote on that. All those in favor? All those against? Okay. Motion's failed. So let's resume debate on the motion that Mr. Brock put on the table initially at the first hour. And the floor is anyone's to speak to. Ms. Lattanzi first.
Yeah. Mr. Chair, this is a study that we, on the C9, we absolutely want to collaborate, and we want to make sure that Bill C9 moves through this committee efficiently and responsibly. This is not about rushing the process. It's about just studying legislation that is meaningful so we can have the protections in place in the House of Commons as soon as possible. I remind everybody that today is October 7th, a very significant day, and the piece of legislation that we have before us would solve some of the issues that communities in each of our ridings, stakeholders in each of our ridings have asked us to look at, to study, and to come up with legislation as soon as possible. The way that the motion is drafted, we are looking at 10 meetings, Mr. Chair. I am of the opinion that we can easily have this disposed of in a matter of 5 meetings at most or at best, however you want to qualify that. And should members stick to a number of 10 meetings, which will obviously take up a lot of the committee's time, then, and I understand that the suggestion last time around was to study this concurrently, then I suggest, Mr. Chair, that we increase the number of meetings of this committee so that we can go ahead and, expedite the study and this important piece of legislation.
Get it, just to understand clearly, we're asking for increase the number of meetings between.
I'm not asking increasing the number of meetings. I'm just at this point, I'm not making an amendment as of yet.
Understood.
But I'm just basically trying to color or paint the situation that we find ourselves in. We have an important piece of legislation. Stakeholders in each of our respective communities have asked us to pass this legislation, in an efficient and expedient manner. And I'd like to be able to do so. And I'm looking at the motion, and we're looking at a suggestion of 10 meetings, Mr. Chair, which would bring us, if we look at the 2 constituency weeks, we are not going to be able to dispose of this motion before this Bill C9 before February of 2026. This is a request, an important request and a very serious request from our stakeholders, and I'd like for us to be able to undertake that study as soon as possible. Now, there's been discussion in terms of having it concurrently with the bail study that we've undertaken also, but again, it would not get us to where we need to go with this legislation before the holidays. I'd like to see this back in the House in the month of December. So if colleagues around the table could consider that we do this in a very efficient way, we could consider, 1, bringing down 10 meetings to 5, and if not, if committee is of the opinion that we need 10 meetings, then I suggest, Mr. Chair, that we increase the number of meetings of this committee so that the job gets done, the work gets done by December.
Thank you. That's understood. Mr. Lawton, and then I have Mr. Baber, and then Mr. Maloney, and then Brock.
Thank you, Mr. Chair. So When this committee established its priorities, I think we all agreed, and I'm very grateful that there was a general agreement across party lines of how pressing the concerns were that led to the studies that we championed. And there's a reason that we have decided to lead off with a study of bail and repeat offenders and sentencing, because stakeholders in my riding and across the country have been crying out for action on this file. We have heard from victims groups, we have heard from law enforcement, we have heard from municipalities, we have heard from provinces about how urgently these issues need to be resolved. So I think the work we're doing on this particular study is incredibly important. We do know that C9 is before this committee as well, and I think Mr. Brock's motion to deal with these concurrently recognizes that both are important issues. No one is disagreeing with that. But we know that the Liberal government has promised other legislation that is also likely to go before this committee. So we cannot have a situation in which the studies that we've all as members agreed to adopt get indefinitely punted down the road because of government legislation. So I think it's incredibly important that we do both of these studies concurrently. I think the proposal to have one meeting each week dedicated to each of these priorities is incredibly reasonable. And as for the number of meetings, I have had, I don't have an exact number, but to Ms. Latanzio's point, I have had already numerous requests to appear on C9 specifically from stakeholders that have very active participation on this, from individuals representing a range of ethnic communities, religious communities, legal interests. So I do not want to shortchange a very important study that needs to take place on C9. And I think 10 meetings is very reasonable on that. I think it's more important to do it right than to rush something like this.
And not to be argumentative, Mr. Lawton, but you do understand it's the practice of the House and committees that these pieces of legislation that are referred to us do have priority, and that is extremely important for the members here to be seized of. There is a relationship between the two. I think we'll be very serious in considering the number of meetings that we do need to meet, but the House has asked us to consider that, and they are of extreme importance to the people that put us in those seats.
I believe that's a point of debate, Chair. I mean, on the motion itself, which is to do these things concurrently, I'm debating the merits of Mr. Brock's
again,
proposal.
we're masters of our own destiny, and we'll decide accordingly, but that priority should rest on our minds. Who is after Mr. Baber, and then Maloney?
The Conservative members are of the view that Bill C9 is fraught with a lot of issues, and therefore it requires considerable attention. Anything less than 10 meetings would not enable the various stakeholders. As Ms. Latanzio can imagine, there's a lot of interest in this bill, and not necessarily good interest, given some of the concerns articulated in the definitions or the reduction of threshold with respect to meeting the threshold of hatred. There's concerns with private prosecutions with respect to hate charges that could be instituted without the consent of the Attorney General. There's the application of the new standalone criminal offense on conduct that is prescribed by any other act of Parliament. So we can have a civil statute like the Canada Labour Code violation potentially attracting a criminal charge. And so there's a lot to be concerned about with respect to what the Liberals are proposing in C9, and that requires that we give it fulsome consideration. At the same time, as a member of the Jewish community, I take considerable exception to Ms. Latanzio's point that today being October 7th means that somehow this bill is going to address some of the issues that have arisen under this Liberal government since October 7th. In fact, the vast majority that is concerning today the Jewish community is already criminalized. Most of the behavior that concerns us is already criminalized in the criminal code. Yet, unfortunately, because of the tone set by this government, does not attract enforcement, whether it's incitement to violence that we're hearing on the streets of Toronto and Montreal. Today, at the University of Toronto, students are glorifying the martyrs. They're glorifying murder on the second anniversary of October 7th. And so I take some exception to the suggestion that with it being October 7th, we need to do something or other. But definitely, we cannot have a situation where we don't give Bill C-9 a very serious look. Thank you.
Thank you. Mr. Maloney.
Yeah, thanks, Chair. Look, there's always irony, I find, in some things we do, and this is no exception. You know, Mr. Lawton pointed out earlier with one of our witnesses on the first panel that her research didn't include speaking to victims, and which I'm thinking he was alluding to that being a flaw in her approach. The next panel of witnesses we have now waiting for us includes the Victim Services of Brant, which would address some of those issues that he raised. And yet here we are delaying, dealing with C9. Also, he made the point of saying he's had numerous requests for people to appear on C9, and he doesn't want to disappoint them. And he feels very strongly about this bill, and as do they, which is why we need to proceed with C9. And we shouldn't bifurcate the process and deal with the current study. Mr. Barber says Bill C-9 is fraught with issues. Maybe it is. Maybe you're right. Let's get the witnesses in and hear them. That's what we're doing here. The legislation is before the committee, as the chair has quite rightly pointed out. Committees are masters of their own domain, but this bill has been referred to this committee. It's been a standing practice of this place since I've been here for 10 years that legislation takes priority. So let's deal with it. Let's get those witnesses Mr. Lawton wants in here. Let's address those concerns that Mr. Barber has. And here's the other thing. We did agree. We worked very well together, Mr. Lawton, a few weeks ago with Mr. Fortin and all of the people around this table, and we agreed on an approach, an agenda, and a sequence of events for what we're going to do. We worked very well together, I thought, sort of merging all of these various motions because we agree that bail reform and sentencing is an issue that we all feel strongly about and we need to address. But so is C9. And if we do this the way you're talking about, C9 will not get back to the House until the new year. We all know that bail reform legislations and sentencing legislation is coming. The minister has been quite clear about that. The most logical way to proceed based on this spirit of cooperation that we've shown so far is to deal with C9, get it done. We can sort out the number of meetings required to do that, whether it's 4 or 9, whatever that is. We can sort that out. And then once that's done, we can get back to the study we're doing now, which might dovetail nicely with the legislation that's coming. It's certainly not going to be a setback, and it could be an advantage. So it seems to me to be completely illogical and inconsistent with what the approach we've been taking to try to bifurcate this process right now. I see the only way to look at it is it's an effort to delay so that no legislation gets back to the House. And we have an obligation as a committee, whether you like it or not. We don't have a majority government, Mr. Barber, so we can't ram legislation through the committee or the House. So let's get here. Let's call the witnesses you want. Let's call all the witnesses everybody around this table wants to hear from and deal with the legislation, which Mr. Lawton has said is so important, because that's what we're here to do. We know the minister is scheduled to come on Thursday. Let's get it started and get moving, and we can get back to the other study, maybe at the same time as we're studying the next piece of legislation, and that is highly efficient. Thank you.
Thank you, Mr. Brock.
Okay, it is now 10 to 5. We have a second panel, and I personally invited one of those witnesses to attend, the manager of Victim Services of Brant. I certainly want to hear from her. I think we've all had a chance to say our piece and to identify the priorities and the importance of Bill C-9, which we don't take any issue with. But I'm not hearing any sort of support in terms of a concurrent study with bail and sentencing reforms. So if I'm the last speaker, I'm actually moving to vote at this point, sir.
Mr. Fortin first.
Est-ce que je suis le seul?
Am I the only one left to speak? Well, you're the only one up until a few minutes ago. Well, I was going to call for the vote in any event, Mr. Chair. Well, if I can't call for the vote, let me tell you this. I find this a tad unusual that we're making people wait as just debating whether or not we should make them wait. It's a bit unusual. We already agreed that we would deal with C9 and the current study one after the other. I agree with that. Ms. Latenzia's proposal is an interesting one, increasing the number of meetings. I would agree with that. I also have a study that's that we won't be looking at until the spring, which is also waiting. So I'd like us to vote quickly, and if colleagues who are going to speak after me agree with me, I ask them to call for the vote too.
Monsieur Chang. Ensuite, Monsieur Maloney, puis Madame
Yeah,
Lazio.
Mr. Baber said that there are many issues with C9. So could you please list some of the major issues? I have personal experience that. No. I have a personal experience that I want to share. As the first gay Asian member of this House, I did experience some personal issues in 2022. Let me share some figures with you. Hate crime on sexual orientation is 69% from 2022. Okay, and then it's 6% increase from 2022 regarding race. So in 2022, in August, in Metrotown, in my riding, I was waiting for SkyTrain. So there are transit aid on both of the platform. So I was actually reading one of the signs, and it says Douglas College, blah, 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 blah. And one of the guys in front of the transit aid, he was shouting at me, like, what are you looking at, Asian? If you want to F-word, go to Davie Street. Isn't this part of the hate crime here in this country? So C9 is very important to me personally and to Canada. And as Mr. Baber said, you say C9 has a lot of issues. What are the major issues? It was unfortunate that that happened to me personally. And that's one of the reasons I'm in the House now. What are you looking at, Asian? If you want to F-word, go to Davie Street. That was very insulting. So C9 is very important to me personally and to many members of my community, the 2S LGBTQI+ community, the Asian community. And a lot of people in my riding told me they want us to study on C9 ASAP. As I mentioned many times, Burnaby Central is one of the most diverse communities here in Canada. And yet, hate crime is on the rise. Thank you, Mr. Speaker.
Thank you, Mr. Chang. Mr. Maloney.
Thanks, Mr. Chair. I want to thank Mr. Chang for his comments. Another reason why we should proceed with this bill. Look, it seems ludicrous to me that we're sitting here, every single member on this table has talked about how important C9 is, and yet what we're debating is a motion to delay it. Like it's counterintuitive. Somebody's going to have to explain to me the rationale behind that if it is anything other than wanting to delay the legislation. Because you can't on the one hand say it's important, you can't on the same hand say that it's something we need to deal with because it's critical, and then say you want to delay it. It doesn't make any sense. And Mr. Fortin, I agree with you completely. Your motion is in the hopper. It's waiting to be debated. If we adopt Mr. Brock's motion, your motion will be delayed further, because if you game this out, if you follow the sequence of events, if we get C9 done, we can then get back to the bail study, which will probably coincide with the bail legislation. That would allow both of those bills to get through this committee faster, more efficiently, and would allow us an opportunity to get to your study. If we adopt the approach Mr. Brock has outlined, what we're going to do is we're going to have two parallel tracks, which is going to delay both, because then we're going to go down this road with the bail study, probably get the bail legislation, still be dealing with C9, and we're going to be so logjam in this committee. Mr. Fortin, you can, be as optimistic as you want, sir, and hope that your study gets before this committee. But in that scenario, the likelihood of that happening diminishes rapidly. So the only logical way to do this is to proceed in the fashion that we agreed to early. And look, it's not like this was not anticipated. When we were talking about what studies we were going to do, we talked about a scenario in which the Justice Minister would appear, either one, to talk about his mandate, or the timing of it could coincide with legislation. That's what's now is what's happening on Thursday. If we proceed as we currently plan with C9 first and then the bail study / bill when it comes, we could have that opportunity again and kill two birds with one stone, as opposed to the minister coming in. I suspect he's going to get questions about bail when he's here on C9, and we're going to get into this duplicating process, and we're going to waste time and have more motions that are unproductive. If we want to be efficient and we want to get all of these things accomplished, which everybody says they do, the only way, sir, to do it is to do C9 on its own, finish it, move back to the bail study, which will coincide with the legislation, and then we can get to your study. So I'm not trying to delay your study. I want to get on with it too. But we're not going to, I can almost guarantee it's not going to happen if we adopt Mr. Brock's motion, because it's a channel for further delay. And the irony, again, I will say, it makes no sense. And I would really like somebody on the other side to explain to me how they're so eager to deal with C9 and so anxious to get all these witnesses here, and yet they don't want to go ahead and study the legislation. It just doesn't make any sense. So, Mr. Fortin, I'm urging you to consider voting against Mr. Brock's motion, because it will assist you in achieving your goal. And we are, and I will agree with Mr. Brock, this motion has caused delay that's completely unnecessary, and I didn't realize that was yours, Mr. Brock. That's very unfortunate. And you can apologize to them afterwards for this unnecessary waste of their time. Thank you, Chair.
Ms. Latanzio, and then I have Mr. Brock and Mr. Lawton.
Thank you, Mr. Chair. I just want to recall in terms of the objective of C9, right? So Canada has seen a rise in anti-Semitism, Islamophobia, and other hate-motivated crimes targeting religious, cultural, and community spaces. I would like to remind the committee that this bill aims to close the gaps in the criminal code by extending protections to these spaces, like safeguards for health facilities. It also clarifies the definition of hatred, removes the need for the AG's consent on hate propaganda charges, helps law enforcement respond more consistently and quickly, and at the same time, it preserves lawful protest and free expression while clearly distinguishing from the conduct that it intimidates, obstructs, or promotes hatred. Now, Mr. Chair, there have been comments made around the table in terms of what this bill would do and perhaps questions being raised. I would suggest to the members that the purpose of this bill, the first pillar of this bill, is proposing a new obstructive offense. This bill would create a new offense making it illegal to block or interfere with lawful access to places like religious institutions, cultural centers, schools, seniors' residencies, or cemeteries, primarily serving identifiable groups. It mirrors existing protections around health facilities and ensure that these protests are peaceful expressions. They exist and that they can remain lawful. It also proposes a new intimidation offense. A new intimidation offense would criminalize.
I'm sorry, Mr. Chair. Ms. Latanzio is reading Bill C9. We are debating a motion about how this committee is to engage in its business moving forward. The Liberals are filibustering at this very moment, a meeting they said they would dispense with in 10 minutes. They have now spent nearly half an hour and are insulting this committee by just reading the bill that we're set to start studying on in 2 days. If they want to move on with this, as they claim they do, they need to stop their filibuster now, let us vote on the motion, and speak to the witnesses who have been waiting very patiently while they obstruct this committee's work.
Mr. Chair, can I continue? I'm on topic.
It was a relevance point of order.
Are you ruling on that? Okay. So the proposed bill would create a new intimidation offense which would criminalize the conduct intended to instill fear in people trying to access those same places and spaces. The new bill would target threatening, menacing, or fear-provoking behavior outside community or religious buildings while also protecting lawful protest and free expression. With regards to hate, which is what my colleague has brought up, colleague Baber, the bill would also propose and strengthen Canada's response to hate-motivated crime. It creates a new hate crime offense applying to any federal offense broken out of hatred, introduces a new offense for publicly displaying hate or...
Ms. is actually reading the bill and the talking points on Bill C-9. It is not relevant to the meeting we're currently having. We have witnesses who've patiently been waiting for over half an hour. We have a witness invited by the vice chair of the committee, and we're asking Ms. Latanzio to stop this filibuster, vote on the motion, so we can at least accommodate one round of questioning with the witnesses we have before us today.
You'll remember that I did allow you some leniency on yours. C9 is on point, and how she presents it is entirely her discretion.
Mr. Chair, I'm just for the committee to be made aware in terms of the relevance of Bill C9 and what it proposes to do, right? So the importance of this bill, and basically to echo what our stakeholders have been asking us to do, to look at this very important piece of legislation. And what I'm trying to convey to the committee members is that this is a very important study, and we must be efficient, and we must take the necessary time to be able to look at it as soon as possible, because we've said this time and time again by myself and my colleague Maloney. If we do agree to the 10 sessions that are being proposed by Mr. Brock, this piece of legislation will not be disposed of in a timely manner in this committee. We're looking at least February, if not March of 2026. We would not be efficient and respond to...
Point of order. Ms. Latanzio is the parliamentary secretary to the Minister of Justice. I've listened to the last 5 or 6 minutes of her simply reading out Bill C9, which is public. We all have the ability to read it. We don't need instructions from a parliamentary secretary to read out the important provisions of Bill C9. This is nothing more than a classic liberal filibuster, which is extremely disrespectful to my witness who traveled here from Brantford, some 6 hours away, to give relevant, cogent evidence about the impact of sentencing and bail issues in our country. And to listen to Ms. Latanzio and listen to Mr. Maloney and listen to Mr. Chang repeat the same argument over and over and over again with every single attempt that we raise to call a vote is disgusting. Absolutely disgusting. And there is a protocol, I believe, Mr. Chair, on a filibuster that there is a prohibition on simply reading out for the sake of reading out. We all have access to Bill C9. We agreed as a conservative caucus, we agreed to allow debate to collapse after 2 days, approximately 6 hours worth of debate, to bring it to committee. We are not arguing regarding the importance and the seriousness of Bill C9, but my God, let's get on with this. This is disgusting behavior.
Thank you, Mr. Brock. And again, I've ruled on the relevance, and Ms. Latanzio can continue.
Okay. Thank you, Mr. Chair. I think that to answer my colleague Brock, I think what is despicable is that we have witnesses that were ready to render their testimony today. We made a decision at the beginning. You actually made the decision, Mr. Chair, to be able to postpone this to the end of the meeting. And what we've done is we've interjected this in between before this witness, that is Mr. Brock's witness, to be able to reintroduce this motion and go back on the ruling that you had made earlier. So I am not reading straight out from the bill. I think that if you have the bill in front of you, I am adding context to the importance of C9. And what I'm telling you is the scope. So because there's a lot in this bill C9, and there's an objective. Now, unless, Mr. Chair, you want to suspend, but if not, I reserve the right to just keep going and illustrate to committee members and the public at large the significance and the importance of C9. The legislation will strengthen Canada's response to hate-motivated crime. It creates a new hate crime offence applying to any federal offence broken out of hatred, introduces a new offence for publicly displaying hate or terrorist symbols to promote hatred. It is a new offence that codifies the legal meaning of hatred and removes the Attorney General's consent requirement for hate propaganda charges, making enforcement swifter and more consistent. Any federal offense would capture all offenses in the Criminal Code or any other federal law, such as the Firearms Act. It would serve to broadly and explicitly denounce all criminal conduct motivated by hate. For example, vandalism of a cultural center motivated by anti-religious hate, or the public display of Nazi symbols or terrorist insignia to willfully promote hatred. Also, it would propose the codification of the definition of hatred. The bill clarifies what conduct is captured by the new hate crime offense, as well as the existing hate propaganda offenses, and supports a more consistent use of these offenses by law enforcement. Based on the Supreme Court of Canada jurisprudence, Mr. Chair, the definition is also centered on the concept of vilification and detestation. It also specifies what is not hatred, namely mere dislike or disdain, or acts that merely offend or humiliate. The measure was included in the former Bill C-63. Furthermore, it also proposes...
On a point of order. Well, it's all well and good to have our colleagues continue to speak, but could we free up the witnesses out of respect to them? I'm sure that the Quebec Bar Association folks have things to do, and also the Conservatives witnesses. Could we perhaps let them go so we can hear from Ms. Latanzio until she sees fit? Well, listen, there are billable hours for lawyers, aren't there? Well, I'm assuming where we're going here, but I think that we'd have, even if we did proceed, we'd have 5 minutes per witness, so there wouldn't be an opportunity to question the witnesses properly. And dare I say, well, go ahead, Mr. Chairperson. Well, with the little time that we have left, says the Chair, I think that we should indeed release the witnesses. And the whole committee will have to bear that burden, i.e. the fact that witnesses were not able to appear. And on behalf of the committee, I'd like to apologise to them. But this discussion does take precedence somewhat. So indeed, we can release the witnesses at this point. I know that folks got a bit upset, but Mr. Fortin, in the same vein, I'm wondering if you have a proposal. Well, I could suspend for 5 minutes so we can have a huddle and discuss this, if that might save time, to determine if there's a consensus, some kind of middle ground. Well, Mr. Chair, I would have liked to have moved an amendment, but when I saw the debate about whether or not to proceed with C9, what's the purpose of adding a witness or adding meetings? There'd be no end to it. That's why I said I'm ready to vote. If we continue to dig our heels in like this, we'll never start. But if you think it's better to adjourn or to allow the witnesses to be released, but if I can assist in the process?
Let's try to get to a consensus, and if we can do that, great. If not, we'll go back to Ms. Latanzio's point of order. Okay, let's bring this. Let's, okay. On est prêt à reprendre. Before we get to this, and it's very important, but I do want to draw your attention to the budgets that you all have that you all got a copy of. I'm going to assume it's fine. It is pressing because we do need to compensate witnesses for their appearances. So unless there's any objections to that, I will deem that adopted. But it's important that we dispense with that today. Ms. Latanzio, from the discussions, I understood there was a consensus, but it's either clear or clear as mud. So let's perhaps put your proposition forward for the clerk to hear, and we can get it properly reduced to paper, and we can all vote on it, assuming everyone agrees. But let's just get all the words out, and then we can vote.
Sure. So thank you. So the amendment on the motion presented by Mr. Brock is as follows. Instead of 10-minute meetings, Mr. Chair, we propose 5 meetings on the study of C9, concurrent with the other bail study. Each meeting will be 3 hours each. And the first meeting of 3 hours on C9 will commence on October 9th?
Yeah.
No,
2 days from
no, next Tuesday, after Thanksgiving.
break week.
Sorry. Okay. Well, it'll start October 9th, but just with the Minister of Justice appearing here for the first hour. The 3 hours.
And officials the second hour.
Officials the second hour. The subsequent Tuesday, which is October 21st, that will be the first C9 3-hour meeting. Yes.
Then it alternates.
Correct.
We can't, but does it matter whether it's Tuesdays or Thursdays for each one? No, okay.
Donc, ce jeudi, le ministre, la bureaucratie pour l'auteur. Puis ensuite, après,
He doesn't want it. He wants.
and they would alternate in sequence. Yes.
So C9 will be on Thursday, October 23rd. Okay?
C9?
C9 will be October 23rd, Thursday, October. Not the Tuesday. So Tuesday will be yours.
Tuesdays will be bail, Thursdays will be C9.
Okay?
Okay,
So
we're okay with that?
we commence C9 this Thursday with the minister appearing for the first hour.
Thursday, oui.
Ça va être sur C9.
Mais il venait pas sur le...
But wasn't he going to appear about on bail reform? No, he's coming for C9.
You'll have the minister this Thursday 1 hour, and then officials for the next hour. That is a 2-hour sequence. When we return from
The break
what I'm
week.
calling the Thanksgiving break,
Yeah.
we will resume 3 hours on bail
On the
on the
21st.
Tuesday, and then the following
Thursday.
Thursday, we will have 3 hours on
On-
C9, and then we
correct.
will rotate accordingly until
Correct.
the agreed-to meetings are exhausted.
5 meetings.
On a 1 heure.
So we have 1 hour with the minister on C9, second hour with the officials, the public service. So we have 2 hours on C9 on Thursday. Yes, it starts on Thursday. Does that suit you, Mr. Chair?
Wait.
Est-ce que ça vous va?
Are you in agreement?
Okay, are we ready to vote on this?
Est-ce qu'on...
Do we know whether the room is available, clerk, analysts, etc.? All that settled? Let's go then. Well, There may need to be an exception made, but it shouldn't be an issue.
If
We'll vote on the amendment, Mr. Chair.
all those in favor? All those against? Motion is carried. Okay, so we're now at time. I thank everyone for their patience, and we will see you Thursday for the next meeting. Thank you.